Hi, this is Jim Cunningham, and we're going to cover what if my spouse remarries? What happens if you die and your spouse marries someone else? What happens to all your estate? Hi, this is Jim Cunningham, and we're going to talk about what if my spouse remarries? I'm talking about your spouse after somebody dies, right? So this is not just getting a divorce and remarrying. This is if somebody dies, right? So if husband and wife or two spouses, one spouse dies, what happens to that surviving spouse? What happens, right? We're going to talk about that. What can you do about it? What if your spouse remarries? So if this is kind of geared toward protecting your kids, it can also be, if you have a legacy you want to leave to charity, whatever it is. But we're going to talk a little bit about remarriage restrictions, prenups, postnups, and strategies about leaving your assets to your spouse, your surviving spouse, in a trust for your lifetime or not. And we'll talk about, kind of the thought process behind that, kind of what we counsel clients when this issue comes up, or how we counsel clients. And make sure you kind of go through all the possibilities and implement a plan. Obviously, that will give you peace of mind. That's why you do estate planning. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've got 25 years experience. We have offices throughout California. I'm a certified specialist in estate planning, trust and probate law, real estate broker, securities insurance license, and a pilot. These are our lawyers in the firm. And subscribe to our YouTube channel. If you're watching this, click subscribe, and then this will pop up in your feed. If you click the little bell, you get alerted. So if you want, we release these about once a week. So it's good information. So disclaimer, I'm a lawyer. I'm talking. This is not legal advice. Don't listen to this and go out and do a bunch of stuff. This is really for information only. So protecting the inheritance from a subsequent marriage. Here's kind of the classic example. Wanda dies and Hal remarries. W is for wife. Hal is for husband. We're using husband and wife just to keep it straight here. So Wanda is the wife. She dies. Hal remarries. Will the kids get any of their inheritance from Wanda? This is a really common theme that comes up. 2/3 of the time, if it's a male-female marriage, 2/3 of the time, the husband dies first. Statistically, a third of the time, 2/3 of the time, the husband dies first. A third of the time, the wife passes away in a male-female marriage. And what's really interesting is we have a lot of clients where the wife has passed away and the husband remarries pretty quick. And if you're watching this, the reason you might be watching this is because that's what you see happening. And when I talk to my wife about this, she says, it's taken me 31 years to train you. I'm not getting remarried. She says, if something happens to me, you're going to get remarried in about 5 minutes. So it's kind of what happens. I think that's kind of out there. So key terms: community property versus separate property. Very important distinction. We're going to talk about the difference between community property and separate property. So these are things that we'll be talking about. Surviving spouse and deceased spouse. This is within the context of one spouse, one of the two having passed away. So the survivor is obviously the one who's not dead. The deceased spouse is the one that is dead. And when we use those terms, we are using that in the context of a spouse has already passed away. Okay. A living trust, we've covered that in a lot of other materials. A living trust is like a bucket you put stuff into. It's got a handle. The trustees are holding onto the handle. When that trustee stops serving as trustee, that bucket is passed to another person. Power of appointment, we will touch on. This is a kind of a little esoteric but important legal aspect, meaning you can be a beneficiary of a trust, meaning you can have a spouse die, and because we'll talk about this, a spouse leaves property in trust to the surviving spouse. You can give the surviving spouse, if you're the deceased spouse, right? So you're the one who's passed away, and now your surviving spouse is enjoying the, your half of the community property and your separate property that you left for your surviving spouse. You can or not, you can leave the survivor the ability to decide who gets that property when the survivor dies. So you can give the surviving spouse a lot of control or not. A power of appointment is the power to alter who gets the property after somebody dies, right? And they're a beneficiary of the trust, or they get the goods, right? They're the person who gets income and principal from the trust. This is best understood as a power to disappoint, meaning this property is going to go to, my wife dies, she leaves a trust for me, and then that money goes to our 3 kids. I have a power of appointment. I can disappoint the kids by leaving that property to somebody else, maybe a charity, maybe one of the kids and not the other 2. So you can see that the people who get less are disappointed, hence the term, the power to disappoint. Non-pro rata division of property. The California permits you to, when somebody dies and you are splitting the sheets, you are dividing up the property, California law does provide that, somebody can get a thing and somebody else can get money. So if you have, a simple example is a $500,000 house and $500,000 in cash and two people who are inheriting, California law, if the trust is written this way or the will is written this way, does allow for one person to get the house, the $500,000 house, and the other person to get the $500,000 in cash. So it's very important. That would be a non-pro rata division of property. A little technical, but just understand these are some important terms. Well, understanding community property for estate planning purposes, very important. I'm not going to bore you with all this. This is foundational stuff that you need to know before we can really talk about what happens when somebody dies and then that surviving spouse remarries. So something to understand, and I'm going to go back to my community property class, and this is exactly how my professor said it, and I remember it's a long time ago, and I remember exactly how she said it. Spouses can leave all their separate property and their respective one half of the community property, however they want. Now, let me say this another way. If I bring money to a marriage, right? Bring $100,000 to the marriage, that is separate property. When I die, if that is identifiable, I can leave that however I want, and my spouse doesn't have any say. Anything that's acquired during the marriage is community property, so wages, that sort of a thing. I can leave my half of the community property any way that I want, my half of the community property. So if there's $1 million in community property, I can leave my $500,000 any way I want. Now, this is why I mentioned non-pro rata distribution, because somebody's going to be dividing this up, right? Some executor or trustee, they can decide who gets what. So this is something important to cover with your lawyer when you do estate planning. So characterization of assets as community or separate matters at death and divorce, but the rules are different. So we are talking for the purposes of death. There's an axiom when in California, to California law, that title controls. What does that mean? Whatever the title of the property is, that is it, right? That controls. Now, can you go to court and maybe make an argument, whatever argument you're going to make? Absolutely. But I'm saying on a very high level, title controls. Within the context of a divorce, title does not control, meaning one spouse can deposit their wages into a bank account. And then, if I have 100,000 in wages and then my spouse files for divorce, even though that 100,000 is just in my name, it does not make it separate property, right? That is still community property because we look at the source of the funds. A little bit different at death. So the rules are different at death than they are during life. So community property, marital property, is all property acquired during the marriage, except property brought to the marriage or received as an inheritance or a gift, and not transmuted. Okay, so if community property is everything you acquire during your marriage, except things that you bring to the marriage or inheritances, that is the definition of separate property, right? It's what you bring to the marriage, or it is an inheritance or gift during the marriage. This can be easily transmuted to community property. So this is very important to understand. It's very easy for separate property to become community property. It is really hard for community property to become separate property. Really, each spouse has to get a lawyer, frankly, to go from community to separate property. And that's a much bigger deal. A separate property can be transmuted or can become community property. And the classic example from law school is the pillow talk transmutation, meaning two spouses are laying in bed at night and one spouse turns to the other and says, honey, I love you so much. You know that $100,000 I brought to the marriage? I really think that's going to be community property. If you can prove that in a divorce setting, you know what? A judge very well may find that that property has been transmuted, that separate property has been transmuted to community property. So California is a community property state. And again, everything acquired during marriage is community property. And this includes real estate. Again, even if just one spouse's name is on there, or an acquired business entity, this is a really common one. Only one spouse is involved in the business and maybe the other spouse is not involved. Well, absent a prenuptial agreement, which is an agreement where you go into the marriage and you say, look, any earnings are going to be community or they're going to be separate. You can agree before marriage. That's a prenuptial agreement. You can agree after marriage. That is a postnuptial agreement. Okay. So you can agree, you can opt out, if you will. But if you don't have a written agreement, or they can't find a written agreement when there's a divorce, which is another issue, right? Somehow magically gets torn up and disappears, sprouts legs and walks away. So you're working in a business, you're going to work every day, you're building that business, that is a community asset, right? Even if one spouse is working in the business. So here's a map of community property states. It's kind of the former, parts of Mexico and Louisiana, and then Washington, Idaho, and Wisconsin. So a lot of states are not community property states. Those are what we call marital property states, where they have an equitable division. So we're only talking here about community property, specifically California. The rules are different in Texas for community property, for example. So just because California is doing it one way does not mean the other states have to do it that way. 50 states, 50 different little experiments. So I'm going to use community property. We're going to have 3 examples here. We're going to go through these quickly. Example 1, Hal and Wanda marry, and Wanda brings $100,000 to the marriage. After marrying, Hal and Wanda buy a home. Now, when you buy a piece of real property, the title company in California is going to go, hey, there's 9 choices, 9 ways to take title if you're married. Which one do you want? And Hal and Wanda are like, I don't know. Joint tenants, I guess. It was the first on the list. Maybe, I don't know. If Hal and Wanda divorce, a court will decide what is community versus separate property, right? Has there been a transmutation? Has there been a pillow talk transmutation? I have no idea. But at death, the survivor, if you own property as joint tenants, the survivor, the last man or last woman standing, gets the property. So in this case, whoever the surviving spouse is, whether that's Hal or Wanda, the survivor gets all of the property, okay, based on title. That's a little bit, the title controls rule, right? So same facts. Hal and Wanda get married. Wanda brings $100,000 to the marriage. They buy a house and take title as community property. Now, if they divorce, a court very well likely will look at the deed and say, well, Wanda, you transmuted that property when you took title as community property. So a court will, and under these limited facts, a court will likely treat this as community property. Now, at death, the will determines who gets the deceased spouse's half of the property. And we'll have an example later if you don't have a will. But remember, in joint tenancy, even if you have a will, it doesn't affect, or living trust, joint tenancy, the survivor gets it. But in this example, because it's community property, because it's a different way of holding title, one of the 9 ways, right? It's a different result. So it's distributed under the deceased spouse's will. Example 3, Hal and Wanda they get married. Wanda brings $100,000 to the marriage. After marrying, Hal and Wanda buy a house and take title in their joint revocable living trust. Now, if they divorce, a court's going to decide what's community versus separate, kind of similar to the joint tenancy structure. But at death, the living trust will direct who gets the deceased spouse's half of the property. So in looking at the trust, when one spouse dies, you'll look at the trust and say, well, it goes this way or that way. And the living trust will control. We have some questions here. We have a question. Mary asks, if I have a separate property trust with significant assets going to my children and I pass away first, does that amount get added to my half of the community property that goes to my spouse, possibly leading to an estate tax problem if the total exceeds the exemption after 2025? Is there a solution to this problem? Well, Mary, based on those limited facts, I would say if you have a separate property trust, and this is, I'm not sure if it was inheritance or where it was coming from, when you die, we look at the total value of all your assets. So this would be your separate property, and this would also be your half of the community property, if you will. And whatever your spouse gets, provided your spouse is a U.S. citizen, whatever your spouse gets, there's an unlimited marital deduction, that meaning the spouse can inherit an unlimited amount. If what you're leaving your children when you pass away exceeds the death tax exemption amount, which is currently $12,920,000, going to be cut in half in 2026 to basically 7, right, ish, then you could be subject, then your estate could be subject to death taxes. So I'm hoping I'm answering this question, but it really is number specific. But your property that goes to your children would be taxable. So if it exceeds, right, that exemption amount, there potentially could be some tax due. But that's something we can help you with. Just reach out to us and we can walk through that with you. So impact of subsequent marriage on an estate plan. So what happens when people get married? Now, what I'm talking about, the context here is just not anyone getting married, but I suppose it could be anyone getting married, the examples we have. So impact of marriage on an estate plan, but this is narrowly tailored for the surviving spouse remarrying. So this is really important. under California law, the fact of marriage changes the estate plan automatically, okay? Really to protect the new spouse's inheritance rights. So what do I mean by the fact of marriage? Well, when you get married, all right, it changes the estate plan. By the way, registered domestic partner is interchangeable with spouse in the state of California. So this also applies to registered domestic partners. Now, a registered domestic partner is anyone over the age of 18 who wants to have a legal part. It's like a marriage without being married. And the reason people do that is to, if they have Social Security benefits, maybe they're older, they don't want to lose a pension. You also, if you remarry and your spouse that passed away, if you filed a 706, which is a death tax return, and picked up something called portability, if you remarry, you'll lose that portability. So very important. I know it's kind of technical, but it's very important. Marriage is a really big deal. And before you say, oh, well, my spouse died, I really want to get remarried, and I'm in love and this is great. Whoa, you really need to meet with your estate lawyer, because you may want to go the path of a registered domestic partner and not marriage for a lot of reasons. But understand that marriage or registered domestic partner automatically changes the estate plan. Now, what we recommend is if you get married, you should update your estate plan, because all you need to do is update it, right? You can say, yeah, I got married and I want to leave my spouse something or not, but you have to mention the spouse. If your spouse is not mentioned in the estate plan, and really the most common instance is where you did your estate plan and then you got married, because most people don't forget to put their spouse, right? In probably a whole bunch of other problems there if you forget about your spouse or you forget that you're married. So it's very important that you mention that spouse. Now, some of our clients have, when clients come in and they're not married and they say, well, we're life partners and we're not married, one of my first questions is either of you married, right? Are either of you married? And the reason is some people got married, but they never bothered to get a divorce, and we just live our lives. But you can only have one spouse, right? And so if you're married, that is one reason that people that people don't get married sometimes when clients come in. And you need to address that in your estate plan. So you would need to say, yes, I'm married to this person, I'm leaving them nothing. And that way they get nothing. Otherwise they're a forgotten or omitted spouse. So subsequent marriage on estate plan. So what happens? The deceased spouse's community property assets, all of them go to the surviving spouse. So let me give you an example. Wanda dies, Hal remarries Betty, okay? Hal does not update his estate plan. When Hal dies, a court will decide what's community and what's separate. And Betty's going to get all of the community property. And depending on how many kids Hal has, Betty will either get half if there's only one child, or she'll get a third if it's more than one child. Okay, so understand that marriage, getting married, changes the estate plan. So when somebody says, oh, I'm going to get married, Wanda dies, and Hal says, well, I'm going to get married, but I still want to leave everything to my kids. Hal, you need to get back into the lawyer's office and update your estate plan, because it's not all going to the kids. A good chunk of that will be going to your new surviving spouse. It'll be going to Betty, right? So, we're going to shift now to planning. We've kind of identified the issues. There's this sort of, is the juice worth the squeeze, right? So if you're squeezing orange juice, like how much juice do you want to wring out of the orange? So there are different schools of thought. And really the two schools of thought are, hey, look, the door swings both ways on this. If one of us dies first, I just want to leave everything to the other one. And I know my surviving spouse will do the right thing. I was talking to a client about that yesterday. That's a perfectly valid approach. Some people say in certain contexts, and maybe with a blended family. What do I mean by a blended family? Kind of like the Brady Bunch, where they each had their own 3 kids and they made a new family. That's what we call in law a blended family. And you might say, you know what, I do want to leave my spouse something, but I also want to leave my kids something, maybe later, maybe when you pass away. So there are different families, different dynamics, and we'll go through a few examples here. So let's go back to this. Wanda dies and Hal remarries. Is the son going to get to see any of his inheritance from Wanda? Remember, Hal can leave whatever. Look, Hal can decide to leave his half however he wants, right? But the issue here, Wanda's concern is, look, if I die first, I know Hal will get remarried in 5 minutes because that's what, she's seen in life, let's say. And she's really concerned about her son getting the inheritance, right? So there are kind of 4 choices here. And the first choice is, look, everything goes to the surviving spouse, and the survivor will do the right thing. That has some advantages, some disadvantages. We'll talk about that a little bit. The second one is, the children should get some money now, right? Or later, right? They should get some money, and the surviving spouse gets some money. And then the third one is the children should get all of the money, the spouse gets nothing, or the spouse gets nothing. So option 1, look, whatever happens, happens. This is typically, you would write up a living trust that says, on the death of the surviving spouse, this trust continues on, and the surviving spouse is now the beneficiary, is now in control. That surviving spouse can change the estate plan however he or she wants, okay? That is kind of a simple distribution. There's no AB trust, there's no ABC trust, there's no ABCD trust, right? The C and D have to do with generation skipping taxes. They can get very complicated. But some other issues are, will the survivor, the two of you, know how to manage the wealth, right? I mean, sometimes people know how to do things, and, people have certain roles in a relationship. And sometimes, many times the widow or widower comes in, like, I have no idea what's going on. I need some help with this. And there may be a chance that your kids get nothing. Okay. So that's another issue. It is possible that the survivor would just change the estate plan and leave it to somebody else. If your spouse is incapacitated, or maybe in a little bit of mental decline, and you're concerned that, look, if something happens to me, what's going to happen to my spouse? You may want to set up a separate type of trust where everything does go to the surviving spouse, but it's in a way that protects him or her. And there's there is the chance that the new spouse, right? If you say, hey, everything goes to the survivor, that new spouse could end up with all the money. And by the way, even on these other trusts, we do see in certain instances that the new spouse kind of taps into these through the surviving spouse, right? So in the case of Hal, so Wanda passes away, Hal remarries Betty. Betty says, hey, Hal, why don't you take me on vacation? Hey, Hal, why don't you buy me this? Hal, why don't you buy me that? And there's a way that they can tap that, even with some guardrails around it. So option 2 is, kids should get some money, okay? Now, here are a couple of approaches. A specific gift. Some people say, yeah, I'm going to give my kids 50,000 when I pass away, 100,000, whatever it is, 10,000, 5,000, a million. I don't know. Here's your check. And then everything else goes to the surviving spouse, right? Or it's retained in trust or doled out. So you can say, look, when I pass away, I'm going to put this $100,000 into a trust. My daughter has special needs, and I want to have that money be used for her benefit. That would be protective, like a protective trust. And then sometimes people say, yeah, I'm going to leave $1 million to my daughter, and she didn't save for retirement, and she's not good with money, and I want her to get $4,000 or $5,000 a month, and until it's gone. That would be an example of another sort of protective trust. We call that a dole it out trust. So if you've got a beneficiary or a person there who's not really good with money, and you're really concerned about that person's ability to manage it, you can put some protection around it. You can also do a contract to make a will. We don't see these too often. This is provided in government probate code section 21,700. And what this says is, we mutually promise that whoever the survivor is, that the survivor will leave half of his or her estate in this manner, okay? You can document that. Again, we don't do this a whole lot. We typically will use a trust structure rather than a contract to make a will. But I did want to cover that because it is out there. We just don't see this too often in practice, but no, it is out there. And then, so we had a question here, and this slide will answer your question. So Anonymous asks, is it better for a married couple to have a single trust or 2 individual trusts? Anonymous, great question. In California, we're a community property state. We typically do a joint trust. But so it's kind of the foundational, the default, rather, for married people in California is a joint trust. Sometimes and there was a question earlier about, I have a separate property trust. Sometimes we will do a separate trust for separate property. And you can have as many trusts as you want. There's really not, a revocable trust. You're going to spend some money to set it up. There's not a lot of maintenance on a trust, unlike a corporation or something like that, or an LLC, you've got maintenance, but these are pretty innocuous. You write up a document, you sign as trustee. Yeah, I'm putting 500,000 in a separate property trust. And when I die, that goes to my kids. That would be an example of having a separate trust. But in California, we typically use joint trusts. Non-community property states typically use separate trusts. So really it depends on your state of residence. If you're in a community property state, you'll probably end up with a joint trust, unless there's a reason not to, which we're going to talk about here. So this is really helpful in a blended family situation. So I want to give you some context on this. When a person passes away, that trust becomes irrevocable. Every person who would be entitled to inherit from that person who passed away, every person who is entitled to inherit as an intestate heir can get a copy of that trust. They can see the terms of the trust. So what's interesting about this is, like, take the Brady Bunch situation, right? If you got his 3 kids and her 3 kids, well, if she dies, she may not want his 3 kids seeing her trust and how it's distributed to her girls. You see where I'm going with this? So there's a real privacy issue. So what we do, if people have divergent estate plans, and where I'm going with this is, husband and wife get married and the husband says, look, I want my half of the property maybe to go to you for your lifetime, but I want my half to go to these other my kids. And she would say, yes, I want my half of the property to go to you. And then I want it to go to my kids later on. What we do many times is what we call a joint pour-over trust. Now, what is this? So it's a joint trust while you're alive. So Hal and Wanda, in this case, do a joint pour-over trust. Hal and Wanda set this trust up. It's like a bucket. There's a handle in the bucket. They put all their assets in the trust, except their IRAs, 401ks, and annuities. Those stay out. So all these assets are in the trust. And when one spouse dies, all the assets come out of that bucket, and the deceased spouse's separate property and the deceased spouse's half of the community property go one way into the deceased spouse's trust, and the surviving spouse, his or her assets go to the his or her trust, right, and their own living trust. And what this does is this gives privacy and kind of shields, the extended family or the family by marriage. They're not going to kind of get into your business. So it's a great way to maintain privacy. And these type of trusts can be also used when the deceased spouse's trust for whatever goes to the surviving spouse or the kids. That can be used to protect the money from creditors, predators, maybe a subsequent divorce. So if that surviving spouse remarries and then gets divorced, that money is going to be protected. So these are some basic architecture items here. We have another question here. Anonymous asks, I have heard that a Q-tip trust can protect children's inheritance if a surviving spouse remarries. Can you explain how it works? Yeah, a Q-tip trust is what is called a qualified terminable interest property trust. And whenever we use the word qualified, that means that the trust has some tax benefit, typically tax advantage. So surviving spouses, and this is for United States citizens, okay, surviving spouses, when the deceased spouse passes away, so in this case, when Wanda passes away, Wanda can leave money for Hal in a trust where Hal receives the income, and Wanda can decide whether Hal gets principal as well, maybe for his health, education, maintenance, and support. And then when Hal passes away, that property can go where Wanda directs it to go. That's a Q-tip trust. By the way, when Hal passes away, that property is included in Hal's estate, so it gets another step up in basis. So there's some advantages to that. It also qualifies for the unlimited marital deduction. What does that mean? That means Wanda, if she had $1 billion, could leave it in a trust for Hal, no death taxes until Hal passes away. So that's a Q-tip trust. Great question. Option 3 is the children get all the money. This is a joint pour-over trust. We talked about this. The child is the trustee. Maybe it's, going back to this basic architecture, the joint pour-over trust. You've got this joint trust where they're alive, and then Wanda passes away, and Wanda's share goes to Wanda's kids, right? And then Hal gets his half. Done. And we see that typically If people remarry later in life, we don't see that so much with younger people. But these are people with significant separate property wealth. So that's where the kids get all the money. Now, who the trustee is really matters. You can have the surviving spouse be the trustee or not, right? So it's where children get all the money. And a lot of times we do that in a joint pour-over trust within the context of a blended family. Anonymous said, I set up my will and trust before I got married and have it split 50-50 between my two kids. Do I need to make adjustments to my current will or trust to create a joint pour-over trust as mentioned? Yeah, Anonymous, I would get on that because again, the fact of marriage, now I don't know what state you're in, but if it's California, the fact of marriage changes the estate plan, which means your new spouse, you're in California, your new spouse is an omitted heir, is a pretermitted heir. So that new spouse would inherit, if you have two kids, a third of the separate property and all of the community property. So I would recommend that you have that looked at right away. If you have a lawyer, you can talk to your lawyer. If you don't, feel free to reach us and we can certainly help you with that. And congratulations on getting married. Option 4, new spouse should get nothing, right? So what are we talking about here? Well, this is where typically it's people who have enough assets and they, I have my stuff, you have your stuff. These are oftentimes people who kind of keep their assets separate anyway. And now this is in the context of the new spouse getting nothing. All right. So new spouse, Wanda dies, Hal marries Betty. Wanda's estate plan says, I am leaving this trust for Hal. But if he remarries, he stops being a beneficiary. I don't like these. I think there's a problem with enforceability. The law favors marriage. The law also abhors a forfeiture. So these are legal maxims. So just because you get married, which is something that the law favors, law favors creation of marriage, creation of families, creation of, these deep social connections. I think, you might have an argument that that's a forfeiture and that could be unenforceable. So some lawyers are a real fan of these. I just historically have had a concern about enforceability. That being said, Hal's rights in this case would terminate when he became remarried. Now you can get more granular on this and you can put some layers on it. So you can require a prenuptial agreement. So one workaround is you can say, look, Hal says to Wanda says to Hal, Wanda dies, Wanda leaves Wanda's estate to Hal. And this trust says, look, Hal, if you get a prenup, you can stay on as a beneficiary, but you cannot add this spouse. You can't exercise a power of appointment, for example, to leave it to Betty when you die. It's got to go to the kids. So you have it while you're alive. It's got to go to the kids. Who the trustee is very important. If Hal's the trustee, it's like the fox watching the hen house, right? Hal would be able to tap into that money. You might want to have somebody else make distributions of principal. So Hal could be in control of day to day, but if there was a big distribution coming out to Hal, you might want to have somebody else in there involved. So these are just little things to think about that really an expert lawyer is going to be able to help you with, which is attorneys at our firm, because we do this all the time. But, it's very important to kind of go through the layers. So if he gets a prenup, it's okay. And then this is the power of appointment issue. So you'd want to address that in your estate plan. Does Wanda want to empower Hal to leave stuff to the new spouse or not? So there are ways to write your estate plan where the new spouse gets nothing. Again, it has to be written in a way, I believe, so that it's enforceable. I don't see a problem with the prenup as a pre-qualification to receiving benefits. I think that's perfectly, it's not a forfeiture because, getting a prenup, not a big deal. Qualified terminal interest property, we talked about that in a question. It allows you to make a gift to your spouse while retaining control how the assets are distributed. It is irrevocable, meaning the survivor cannot change it. It's not like a revocable trust. Your spouse can be the only beneficiary. You can't have your kids on there during their lifetime. And again, if a Q-tip trust terminates on a subsequent marriage, I think that you might not get the marital deduction on that at all. So there's some cases out there that kind of call that into question. This is getting kind of granular on this, but know that if you have a Q-tip trust, if you're a lawyer watching this and you would say, oh, Jim, that kind of makes sense because a Q-tip trust has everything going to the surviving spouse. And that is a unlimited marital deduction, meaning only the spouse can be the beneficiary. Well, if you say that that spouse can stop being the beneficiary at a certain point in time, how do we treat that when Wanda dies, right? So if Wanda's setting this trust up that says Hal's the beneficiary, except if he gets remarried, he stops being the beneficiary, I don't think you're going to get a marital deduction on that gift from that inheritance from Wanda to Hal. So a little bit of, and that's the nasty tax consequences. So you got 4 options, 100% to the, just leave it all to surviving spouse and Scout's honor, you'll do the right thing. Maybe we leave some money to the kids, you know, help them out a little bit. And, or the children get all the money and nothing goes to Hal in this context, or it goes to Hal, right? When Wanda dies, it goes to Hal. But if Hal remarries, that new spouse gets nothing. So if you need help, you can call that number, 866-988-3956. Our offices are in Northern and Southern California, Bay Area, Capital Region, and LA. Go ahead and subscribe to our YouTube page, and I will, if you're watching this, we got another webinar coming up next week, how to live their lives. So I love the graphic there with the $100 bills. Really cool. So there's a link in the description and link in the chat to register for that. So there are a lot of strategies because I know that is a concern for some people that, you know, if you've been blessed and with a lot of material wealth and you say, you know what, I'm not sure I want to leave a kid. I don't want to ruin my kids. I don't want my kids to be trust fund babies. Or maybe you do. I don't know, but we're going to talk about it, right? All right. Well, that brings us to the end of our webinar. If you're watching this on YouTube, stay on because another video is coming right up.